And welcome back to Consumer Choice Radio, broadcasting here on the Big Talker 106.7 FM and Saga 960 AM in the Peel region, Toronto, Canada. We're speaking with Ashley Baker here on the program. She's the Director of Public Policy at the Committee for Justice and our go-to source for all things court and justice related. Ashley, thanks so much for coming back on the program.
Thank you for having me again.
So now a three-time guest, David. She's hitting the leaderboard here, which is very good. So we have a couple things to discuss and talk about, Ashley, but I want to go back to basics because we hear in the news lately that Biden and in Congress, there are sweeping proposals on antitrust and everything related to antitrust, to companies, to breaking them up, to making sure that they don't do this, that they don't do that. We have to go back to the basics and to say, what is the goal of antitrust laws and legislation? You wrote a piece on this in the paragraph. We'll link to that in our show notes. But if you could describe it to our listeners, what is the goal of antitrust overall, and why is that important for these modern debates?
Sure. I think it's a good time to kind of take a step back and look at some of the fundamentals. There's a lot going on in antitrust law right now, and a lot of things are kind of being put under the banner of antitrust and competition. You mentioned goal as a singular term. If you ask the neo-Brandeisian school of thought, really likes to try to use antitrust for a lot of other purposes, whether that's income equality, redistribution of wealth, the environment, name any sort of policy cause there. And, that's really an enforcement objective, but they don't have an anchor, a guiding goal. And that's where the Chicago School, on the other hand, and through the work of Robert Bork and others, the consumer welfare standard is what keeps antitrust law kind of tethered to one objective path, and that's through protecting consumers through promoting the competitive process more broadly.
Oh, and I did want to give you praise for 1 second. I did pick up this beauty, the Antitrust Paradox. Figured you would be interested in this book. I've seen you recommend this along with others, so I'm in the know. I haven't started it yet, but I've got plenty of other readings to do beforehand.
You should. There aren't many books that most 450-page books should be about 150 pages, could easily be shortened. Antitrust Paradox doesn't get enough credit for it really packs a lot in there. It's very well written.
Oh, this is good.
So I have just one follow-up question in terms of, at least my viewpoint here is it's almost like we have like an unholy alliance of progressives and populists advocating for the use of antitrust in all sorts of areas where, from my opinion, they don't apply. And from the court's view, that's kind of slowly playing out depending on the case. I think Facebook was the last one. But I'm just curious as to your thoughts on what is driving the narrative on both sides of that coin, the populist side and the progressive side.
Well, you raise a good point. There are a lot of political undercurrents, and I've pointed this out a couple of times that antitrust kind of does serve as this sort of microcosm of broader political dynamics. And what you're seeing here is you have kind of more the populist right and people who are angry at tech companies who want to use it explicitly for that. And then you have those who have been, on that side of the antitrust debate for decades who want to use it for, a wide variety of objectives. But I think, on the right of center, it's more driven by some of this misconduct by tech companies and, some of this woke behavior, so to speak, by corporations. And I think they have a fair point. It's just antitrust law is not the avenue for that.
Yeah, that's an important point. And I think for some of the avenues of antitrust, many of those efforts will be spearheaded by this new player on the scene, Ready Player One. We have Lina Kahn. She was confirmed by a Senate committee as the chair of the Federal Trade Commission that happened back in June, I believe. She is 32 years old. Oh, wow. Great to see people your age doing much grand things on the Hill and potentially changing the fate of millions of consumers and people throughout the country. So what are your thoughts, Ashley, as to Ms. Kahn? She has someone who's had a lot of things to say about some of these companies that are now being brought up on antitrust violations. And is she someone that we should hold in high regard? Or are there ways that we can be skeptical? Is she someone we can count on, or are there ways that we should beware?
Well, there are a couple of things I would like to note about her confirmation, which is that when she was confirmed, she had been nominated to the position of commissioner. It was kind of given that she would be replacing someone, in a bipartisan commission who was also a Democrat who would presumably vote in future cases the same way that she would. And that's very different than confirming a chair. And while the president does have the authority to elevate a commissioner to chair at any point, it has kind of not been noted other than, one day of a news cycle that the White House really deliberately misled the Senate. Hours after she was confirmed as commissioner, it was announced that she would be chair. So they had already made up their minds. And that's really out of the norm to present a nominee that is not for the position they're being really nominated for. And I think it's really in run around the advise and consent process of the Senate. I think she probably would have been confirmed either way. Maybe her confirmation hearing would have had different questions because there's a huge difference between being commissioner and being chair. And we're seeing that play out right now. The past two open meetings are open, so to speak, held by the FTC, which is a new concept. I'm glad they're having these meetings, but they've allowed for like 4 business days in one instance for public input. The public input that was given in person or virtually now was actually given after the votes. So that's a little bit counterintuitive and really, especially with the first meeting, they rammed things through with a 3-2 vote and made some major policy decisions to rescind some prior guidance. And really, she's trying to take the FTC from running at 25 miles per hour to 250. And we'll see how long that can sustain itself.
So looking at her background and some of her statements, there's obviously a lot that is just perfect for a Democratic administration at this time. She understands a lot of these. She's someone who was an immigrant, went to Yale. She's written papers on things related to antitrust and to Amazon. She's someone who's very well known, at least, and has been in the spotlight. And you say that the FTC is now going to be going, all these different directions. I remember in the sort of argument about net neutrality and everything related to the FCC, Federal Communications Commission, the idea always was that many of these issues people are discussing should be handled more by the FTC. Since they're also discussing about net neutrality coming back, can we trust the FTC as well if it comes to that and we start talking about different ways of the government or the state regulating the internet?
Well, those are two different issues. You bring up net neutrality, which did make an appearance in the executive order that came out earlier this month, and having the FCC, not the FTC, reevaluate their Title II guidelines that were pre-2017. What's interesting about that, though, is now it's being framed as a competition problem. If anyone remembers the debate in 2017, it was about blocking and throttling, and the internet was going to load one word at a time. But now here we are, and the internet's 3 times faster. It's cheaper. It's none of those things happened, not a single one of them, and it's being called a competition problem.
Understandable.
We've seen some of these competition arguments come up. That kind of seems to be the narrative of the day, is that many companies are behaving in monopolistic ways. And there's always the irony of, Elizabeth Warren is the example I can think of where she'll tweet about how monopolistic Facebook is, failing to see the irony in her own tweet. But are there any cases where you see that there may actually be some merit? Or generally speaking, when we're talking about, let's say, tech companies, there's enough competition or healthy competition between platforms, or there aren't barriers to entry. So I'm just interested to see if you can think of any examples where there may actually be merit for the use of antitrust.
Of course, there are hypothetically cases where there could be merit to that. And we have a lot of cases before us that were brought by state AGs, and we've yet to see how those play out. I think we need to see how those play out in court. But antitrust is ultimately about actions taken by companies. It's not about the size itself. It's all of this is framed around a hate for bigness and a willingness to kind of prop up inefficient competitors. And that's really not what this is about. And it's high concentration itself is not an antitrust violation.
Got it. And so Yael and I in a previous show talked about what we called Joe Biden's consumer competition push, his executive order on competition. What do you see as the good and what do you see as the bad in terms of his executive order?
Well, this executive order is incredibly broad. I would not call that good. It has 72, I believe, specific directives to at least a dozen agencies. It creates a new Bureau of Competition. I think the overall goal of eradicating certain barriers to entry, especially when created by the government, that's commendable. And there are some aspects of it regarding like labor and transportation and, for example, making hearing aids available over the counter. That sounds good. I'm not that familiar with that area of policy, but perhaps there's some good stuff there. I know a lot of good things have been said about occupational licensing in this regard, but it's funny because the executive order itself actually mentions occupational licensing as kind of a bad thing when it creates various entries for certain minorities, and then also calls for a re-examination of it. So is it good or is it bad? It doesn't really know. But the order itself, it has predetermined outcomes, and that's problematic more broadly. It's asking, for example, the FCC to engage in a rulemaking process, and it's telling them what the outcome that they should reach will be. What's the point of the notice and comment process when there's already a predetermined outcome?
Yeah, I think with a lot of that, obviously, we praised from our point of view, a lot of talk about open banking, which I think was awesome, the occupational licensing stuff. They even mentioned a little bit about some competition in the alcohol industry, which David and I were very excited about. But there's definitely a lot specific to antitrust that was very problematic. Ashley, Ashley Baker is our guest here. In the closing segment here, Ashley, I want to ask you, what are some things that you're working on at the Committee for Justice? I know Supreme Court sort of season still ongoing, a lot of trials, a lot of cases, a lot of things coming up. What should we keep our ears open for here in the next couple of months before everybody heads off to vacation in August?
Sure. Well, the Supreme Court did just wrap up its term at the end of July, as it does every year, and will resume the first week of October. Obviously, no Justice Breyer retirement news. You would have heard by now. And we've continued to hear these sort of calls for court reform and court packing. We have this presidential commission on the Supreme Court that is going to issue a report in November, which will probably say a lot of things, and it won't make very specific recommendations necessarily. And regarding antitrust, there was finally a deputy attorney general for the antitrust division nominated. It's notable, by the way, that the executive order was issued without someone even being in that position. I thought that was pretty outstanding. That's, not in a good way, that they issued the executive order without a nominee even in place, and have begun kind of starting the first steps in implementing it. So we'll see how his confirmation goes, and also what the FTC does. I mean, like I said, they're moving at a fast pace, and they're moving quickly in the direction too of agency rulemaking. The last time the FTC had broad rulemaking authority, that didn't go so well. So we will see what happens.
Well, there we go. We heard it first here from Ashley Baker. She's the Director of Public Policy at the Committee for Justice. She tweets at and Ashley Says, and we'll link to her writing in the show notes. Ashley, thanks so much for coming back on the program.
Thank you.